American Public Administration Theorists and the U.S. Constitution. Introduction. This paper analyzes the evolution of public administration from 1776 to today. This paper will examine the series of metamorphoses experienced by the field of public administration as well as its theoretical punctuations, with a focus on Woodrow Wilson and Frank Goodnow. By evaluating the theoretical implication and challenges of these approaches at each stage of its development, this paper aims to explain the role the U.S. Constitution has on the evolution of law and discretionary decision-making in the United States. In the U.S., the political values frame is inseparably linked to democracy. The fundamental problem in a democracy is responsibility to all. The responsibility and responsiveness of the administrative agencies and the bureaucracies to the elected officials is of central importance in a government based increasingly on the exercise of discretionary power by the agencies of administration. Democratic participation includes representation, political responsiveness, liberty, and equity, and intrinsic to the notion of participation are other values geared toward the government's responsibility to promote and maintain economic opportunity. Rationality is used in the political public values frame as a direct result of political pluralism in public administration. The founders of the U.S.'s view on rule of law versus discretionary power. The fundamental aim of the separation of powers, which the American founders developed from John Locke's Second Treatise of Government and from Montesquieu's Spirit of the Laws, was to safeguard rights against the possibility of arbitrary government. The talent of acquiring property can give rise to political power, even if not bred from nobility. Madison and the Federalists explained that the ratification of the Constitution was essential for regulating commerce and creating the military. The Federalist 51 expressed the logic of checks and balances. If men were angels, no government would be necessary. Publius Madison, 1957. The Constitution of the United States is held in high regard and continues to provide principles in our contemporary practice of government. The idea of shielding administration, at least to some degree, from political influence has been around in the United States for some time, at least since the reaction against the 19th century spoils system, in which many jobs in the federal bureaucracy were doled out on the basis of one's affiliation with the party currently in power, as opposed to one's actual merit or skill. In order to secure individual rights in a system based upon the rule of law, the founders implemented a constitutional design centered on the separation of powers. Under the separation of powers system, the legitimate authority of government would be exercised by three co-equal departments, each making sure the others remain within the confines of their proper constitutional places. The modern public administration comes out of Franklin Roosevelt's New Deal, which launched a large bureaucracy and empowered it with broad governing authority. The agencies comprising the bureaucracy reside within the executive branch of our national government, but their powers transcend the traditional boundaries of executive power to include both legislative and judicial functions, and these powers are often exercised in a manner that is largely independent of presidential control and altogether independent of political control. While the actual growth of the administrative state can be traced, for the most part, to the New Deal and subsequent outgrowths of the New Deal like the Great Society, the New Deal merely served as the occasion for implementing the ideas of America's progressives, such as Woodrow Wilson and Frank Goodnow. Wilson and Goodnow's dichotomy definitions. The constitutional placement of administration within the executive and under the control of the president was a problem, as the progressives looked to insulate administrators not only from the chief executive, but from politics altogether. Woodrow Wilson served as the 26th President of the United States and was a leading academic advocate of progressive ideas long before his entry into politics. Much of his contribution to progressive thought came in his work from the 1880s when he was in the early stages of a prolific academic career. Goodnow was the founding president of the American Political Science Association and a pioneer in a new field of administrative law who started to make his own contributions to the progressive movement in the last decade of the 19th century. The establishment of the Civil Service Commission through the Pendleton Act of 1883 marked a significant victory for opponents of the spoils system, but it took the progressives, starting with Wilson and Goodnow, to take this opportunity against the influence of politics and administration and make it part of a new understanding of American constitutionalism and part of a broader argument for political reform. Wilson suggested creating a realm of neutral administrative discretion shielded from political influence. Goodnow expanded upon this Wilsonian concept in the 1890s and eventually published the book in 1900 titled Politics and Administration. The fundamental assumption behind the vast discretion that progressives wanted to give to administration was a trust in or optimism about the selflessness, competence, and objectivity of administrators. Just as the sobriety about the potential for tyranny led the framers to circumscribe carefully the authority of the national government, the progressives' passionate optimism fueled their call for maximum discretion for administrators. Wilson came to believe that history had solved the problem of faction, that human nature was no longer a danger in a democratic government. He wrote frequently of a steady and unmistakable growth of nationality of sentiment, and of a growing unity and objectivity in the American mind, and concluded that with the power of the national government could be unfettered because one faction or part of the country was no longer a threat to the rights of another. With the threat of faction having receded as a result of historical progress, Wilson argued, a new understanding of the ends and scope of government was in order. This new understanding required an evolutionary understanding of the Constitution, one in which the ends and scope of government are determined by looking not to the pre-established law of the Constitution, but instead to the new demands placed upon government by contemporary historical circumstances. Wilson's thesis was that it was far better and more efficient for a professional class of experts, instead of a multiplicity of politicians with narrow competing interests, to handle the complex business of the modern state. To the objection that entrusting administrators with such discretion might not comport with the Constitution's distribution of power, Wilson responded that administrative principles and constitutional principles were distinct, and thus that constitutional limitations could not easily be applied to the exercise of administrative authority. Wilson's argument was grounded in the confidence in the expertness and objectivity of the administrative class. Wilson urged special education for future administrators at elite universities. He argued that an intelligent nation cannot be led or ruled save by thoroughly trained and completely educated men. Only comprehensive information and entire mastery of principles and details can qualify for command. Specialization would allow for complex decision-making. He wrote, "If I see a murderous fellow sharpening a knife cleverly, I can borrow his way of sharpening the knife without borrowing his probable intention to commit murder with it. Why should we not use such parts of foreign contrivances as we want, if they be in any way serviceable? We are in no danger of using them in a foreign way. We borrowed rice, but we do not eat it with chopsticks." Like Wilson, Goodnow argued that the government needed to adjust its very purpose and organization to accommodate modern necessities. Goodnow, in his published book on Politics and Administration, 1900, identified two distinct functions of government. One, politics, which has to do with policies or expressions of the state will. Administration has to do with the execution of these policies. In Politics and Administration, Goodnow made clear that his push for administrative reform was not simply or even primarily aimed at correcting the corruption of the spoils system. Progressives had in mind a wide array of new activities in which they wanted national government involvement. Such involvement could not be achieved with the old system of placing administration under political direction. Understanding administrative reform this way, as a means to securing the broader aims of progressive liberalism, is what makes the work of Goodnow and Wilson so much more significant to the development of modern American thought and politics than had been the case with the civil service reformers. Goodnow and his fellow progressives envisioned an almost entirely new purpose for the national government. Government itself, therefore, had to be viewed through a historical lens. The principles of the original Constitution, Goodnow reasoned, may have been appropriate for the founding era, but now, under present conditions, they are working harm rather than good. The error that the founders made was not in constructing government as they did, but rather in thinking that their particular construction and manner of conceiving politics would transcend their own age and would be appropriate for future ages as well. They did not realize the historical contingency of their principles. The modern situation, Goodnow argued, called for less focus on constitutional principle and law and much more focus on empowering and perfecting administration. He repeated Wilson's proclamation from 1885 that the nation had to move from constitutional to administrative questions. The focus of the founders' constitutionalism on government's permanent duty to protect individual rights was an impediment to the marked expansion of government power that progressives desired. Thus, the ideas that animated the founders' concept of government had to be discredited. Goodnow knew that the notion that government's primary duty was to protect rights came from the theory of social compact, a theory that which held that men are naturally endowed with rights prior to the formation of government, and therefore consent to create government only insofar as it will protect their natural rights. The founders' system of government, Goodnow acknowledged, was permeated by the theories of social compact and natural right. The separation of powers limits on government, Goodnow realized, came from the founding era concerned for individual liberty. It was the fear of political tyranny through which liberty might be lost, which led to the adoption of the theories of checks and balances and of the separation of powers. Goodnow found it necessary to critique the theory of natural rights because he knew it was the foundation for the requirement of government based upon consent and the rule of law. The principle of government by the consent of the governed was a problem for Goodnow and those who shared his vision of administrative power. Goodnow's vision required significant deference to expertise. The empowering of administrators, as he saw it, was justified not because the administrators had the consent of the people, but because they were experts in their fields. The key to trusting administrators with that kind of discretion that Goodnow envisioned was his profound faith in the expertness and objectivity of the administrative class, just as it had been for Wilson. Administrators could be freed from political control because they were neutral. Their salary and tenure would take care of any self-interested inclination that might corrupt their decision-making, liberating them to focus solely on truth and the good of the public as a whole. A natural objection here would be that freeing administrators from political control is a recipe for corruption. That is precisely through the electoral connection of public officials that we make their interests coincide with their duty, as Hamilton puts it in the Federalist. But for Goodnow, it is just this connection to electoral politics that would make administrators corrupt, while the absence of accountability to the electorate somehow makes them pure. Politics, Goodnow explained, is polluted and full of bias, whereas administration is all about the truth. The main tenets of the progressive vision for administration, articulated by the likes of Wilson and Goodnow, have come to have a powerful influence in the administrative state by which America is governed today. Is bureaucratic discretion good or bad? In 1935, Congress had enacted the Public Utility Holding Act, which required that public utility holding companies reorganize their corporate structures and that the recently created Securities and Exchange Commission, SEC, oversee and improve the reorganization plans. The law did not name any specific standard that the SEC was to use in evaluating the plans, and the SEC itself did not set any particular rule to govern its decisions. When it became clear that the SEC would allow preferred stockholders to convert their shares of the old company into shares of the newly reorganized company, The Chenery Corporation went out and bought itself a large block of preferred stock on the open market. The reorganization plan approved by the SED did, as expected, allow preferred stockholders to convert their shares, but the SEC explicitly excluded Chenery in making such a conversion, thus depriving Chenery of its ownership. The reason for SEC's exclusion of the Chenery Corporation was that the agency decided that it was impermissible for a management company to purchase stock during a reorganization. This was not a prohibition that was part of any law, rule, or regulation when the Chenery Corporation made the purchase, nor was it a prohibition that applied to any other company other than Chenery, nor was it a prohibition that the SEC ever employed again in the future. It was instead a standard that the SEC invented on the spot and applied retroactively to this one company. The Supreme Court in 1943 Chenery case did not find such an argument compelling, reasoning that before transactions otherwise legal can be outlawed or denied their usual business consequences, they must fall under the ban of some standards of conduct prescribed by an agency of government. That the SEC must, in other words, act according to the rule of law. The Chenery case is now commonly cited in administrative law study as an example of the vast discretion granted to the bureaucratic agencies when Congress delegates to them its legislative power. The case also serves as a good illustration of the kind of injustice the American founders sought to avoid by instituting a constitution structured around the separation of powers and grounded in the rule of law. The agency, on the basis of its expertise, and not Congress on the basis of its electoral connection, is charged with determining the specific policy that best serves the public interest. In another example, legislation on broadcast licenses directs that the Federal Communications Commission, FCC, shall grant licenses if public convenience, interest, or necessity will be served thereby. More recently, the Supreme Court, under William Rehnquist, made clear that there would be no revisiting the abandonment of non-delegation. The FTC is a particularly apt example since it was the quasi-legislative and quasi-judicial character of the FTC that was upheld in 1935 in the landmark Supreme Court case of Humphreys Executor v. United States. The first time that the court so clearly acknowledged that agencies technically within the executive branch could exercise substantially non-executive functions. That such a notion has become ingrained in the American political mindset was evidenced by the near universal outrage expressed over the Supreme Court's 2000 decision in FDA v. Brown and Williamson. In this surprising exception to its standard deference for agencies, the court ruled that before the Food and Drug Administration (FDA) could promulgate and enforce regulations on tobacco, Congress first had to pass a law actually giving the agency the authority to do so. The decision, which simply upheld the rule of law, was denounced because it would subject tobacco regulation to the control of the people's elected representatives in Congress, where tobacco state legislators might derail it instead of giving FDA scientists carte blanche to regulate in accord with their own expertise. However, Title VII of the Civil Rights Act of 1964, the Age Discrimination in Employment Act, and the Americans with Disability Act are examples of lawmaking that applies strict law and far fewer applications of discretion, which enables citizens to both have protected liberties and equal rights, which is what scholars proclaim was the will of the crafters of the Constitution and the Bill of Rights. The contrast here helps us see that the principal differences between the progressive and founding-era notions of what constitutes good government. The founders understood that there are two fundamental ways in which government can exercise its authority. The first is a system of arbitrary rule, where the government decides to act on an ad hoc basis, leaving decisions up to the whim of whatever official or officials happen to be in charge. The second way is to implement a system grounded in the rule of law, where legal rules are made in advance and published, binding both government and citizens and allowing the latter to know exactly what they have to do or not to do in order to avoid the coercive authority of the former. When applying the rule of law, rules are made in advance and applied to the broad array of cases that may arise in the future. The people have the opportunity to consent by way of the deliberation and the votes of their elected representatives. In a situation where ad hoc decision-making is used, a decision is made only once a particular case arises, thus providing no opportunity for the citizens to grant their consent. The rule of law makes it much more difficult for governments to play favorites, to benefit its personal friends, and harm its personal enemies. It is thus the best means of maintaining a government dedicated to the equal protection of its citizens' rights, according to the framers, which is the aim of all legitimate government, according to the Declaration of Independence. Administration as the founders envisioned it was thereby placed within a single branch of government, and a clear line of political accountability for administrators was established so that their exercise of power would take place only within the confines of the law. The progressives proposed that a carefully limited government may have been appropriate for the founding era, when the primary concern was throwing off central government tyranny, but in order for government to handle the demands placed upon it by modern times, the founding era restrictions on its powers and organization would have to be eased and the scope of government expanded. To handle modern dilemmas, current bureaucracies have a delegation of rulemaking or regulatory power from the congressional lawmakers to an enlarged national administrative apparatus, which would be much more capable of managing the intricacies of a modern complex economy because of its expertise and its ability to specialize. The modern bureaucratic state, with its expertise to regulate, is normally responsible within its area of competence for setting specific policies, investigating violations of those policies, and adjudicating disputes. Golembiewski's Four Paradigms of Public Administration. As Golembiewski noted, examining the theorists of the last 1900s to the 1970s, four periods may be characterized according to whether it has locus, the where, or focus, the what. Public administration development as an academic field may be conceived as a succession of four overlapping paradigms. 1. The politics-administration dichotomy, 1900 to 1926. The concentration of study during this period was on locus, the where public administration should be. 2. The principles of administration, 1927 to 1937. The concentration of study during this period was on focus, essential expertise in the form of administrative principles. 3. Public administration as political science, 1950 through 1970. Focus on locus. Paradigm 4. Public administration as public administration, 1956 through 1970. The focus. 1900 through 1926, Goodnow and fellow scholars viewed public administration to center in the government bureaucracy. During the public service movement taking place in American universities in the early part of the century, public administration achieved its first serious attention from scholars. In 1914, the Committee on Instruction in Government of the American Political Science Association issued a statement that political science was concerned with training for citizenship, professional preparations as law, and training experts to prepare specialists for governmental functions. White published in 1926 the first textbook devoted to the field of public administration. The book is considered by Waldo as quintessentially American progressive in character, with theories such as politics should not intrude on administration, management leads itself to scientific study, public administration is capable of becoming a value-free science in its own right, and the mission of administration is economy and efficiency. The notion was to strengthen a distinct politics-administration dichotomy by relating it to a value-fact dichotomy. Public administration would focus on organization theory, budgeting, and personnel, while avoiding elected officials' needs for politics. 1927 through 1937, Willoughby published his book, Principles of Public Administration, 1927, the second fully fledged text in the field depicting certain scientific principles of administration. In the U.S. in the 1930s and early 1940s, public administration was in demand for their managerial knowledge, courted by industry and government alike. Principles were principles and administration was administration. In 1937, Gulick and Urich's papers on the science of administration pointed out the importance of principles to favor management theory. 1938 to 1950, the challenge and the reaction. Bernard's The Functions of the Executive and Simon's Administrative Behavior in 1938, along with Dahl, Waldo, and others, pointed out that for every principle of administration, there is a counter-principle and therefore it is questionable. It was proposed that politics and administration could never be separated in any remotely sensible fashion and could not be dichotomized. This is supported by a theory of public administration means in our time a theory of politics also. In the 1940s and 1950s, public administration didn't want to be excluded from the progressive inquiry, which is of normative political theory, and the concepts of the public interest and public values. Social studies and economics began to overtake the study of public administration. Public administration theorists considered the formulation of public policies within public bureaucracies and their delivery to the polity. 1950 through 1970. In the 1950s, linkages were established between public administration and political science. Public administration was a subject as an emphasis, an area of interest, and a synonym of political science. In the 1960s, organization theory was an overarching focus of public administration, according to Henderson. Organization development began its rapid rise as a specialty in administrative science due to its involvement in social psychology, the opening up of organizations, and the self-actualization of the members. From 1956 through 1970, public administration has been increasingly concerned on areas of policy science, political economy, and public policy making process in its analysis and the measurement of policy outputs. The 1960s and early 1970s were periods of turbulence, instability, and confusion in the West, particularly in the United States. Like other social sciences, such as psychology, sociology, and political science, public administration was shaken by this revolutionary period. The earlier focuses of public administration, such as economy and efficiency, were found inadequate and incomplete objectives to administrative activity. The impact of administration on human character is more important than its efficiency and economy. Public administration cannot be value-free. It has to be value-oriented as certain human values are promoted in society. What is new public administration? The term new public administration was used to describe this new trend in the field of public administration. Books by Marini and Waldo, 1971, gave currency to the concept of new public administration by writing about the Middleburg Conference held in 1968. This conference expressed dissatisfaction with the state of the discipline of public administration and sought to give it a new image by discarding traditional concepts and making it alive to the problems presented by the turbulent times. The literature of the new public administration is anti-positivist, which means they reject the definition of public administration as value-free. They reject the rationalist or perhaps deterministic view of mankind, and they reject any definition of public administration that was not properly involved in policy. NPA was more or less anti-bureaucratic and anti-hierarchical. It stresses the central role of personal and organizational values or ethics. There is an essential relationship between the structures and processes of administrative efforts and their ends and goals. The new public administration advocates a client-centered approach. It wants administrators to provide the people a major voice in how and what is to be provided. Client-focused administration is recommended, along with debureaucratization, democratic decision-making, and decentralization of administrative process in the interest of more effective and human delivery of public services. The new public administration placed emphasis in innovation and change. The keynote of the new public administration is an intense sensitivity to and concern for the societal problems of the day. Its parameters are relevance, morals, ethics, values, innovation, concern for clients, and social equity. In this background, new forms of organization are carved out to suit the fast-changing environment. Critics of the doctrine of NPA hold that this possesses differences only by definition. For example, Campbell argues that it differs from the old public administration only in that it is responsive to a different set of societal problems from those of other periods. The critics also say that NPA tries to arrogate themselves on what falls within the domain of political institutions. Further, the concept of social equity is vague. Opinions of what it means and what it requires in public programs vary. Some theorists remark that public administration theory has not caught up with emerging problems, like the huge military-industrial complex, the decline of the middle class, labor unions and strikes, and public school conflict. The view that NPA has certainly broken fresh ground and seriously jolted the traditional concepts shows that it has imparted new perspective to the discipline of public administration by linking it more closely to society and leading to the new public service. Conclusion: sorting it all out and continued reform. Public administration uses substantive rationality to determine what a social group's goals, values, and ideals should be, Weber, 1946, and engages in reasoning that is deductive, dialectical, and deontological, Pugh, 1991. Thus, the political frame is closely associated with Kantian reasoning, grounded in history and political philosophy. Crime prevention policies might trigger competitions among values such as liberty, safety, due process, equity, effectiveness, access, and justice. And domestic security policies might produce conflict among values such as knowledge generation, information sharing, confidentiality, privacy, civil liberties, individual rights, and safety. The pursuit of liberty can become incompatible with the pursuit of equality, the pursuit of justice, the pursuit of mercy, and the pursuit of spontaneity with that of security. To effectively address public values pluralism, public administrators need mechanisms which to view and understand the relevant public values at play for given policy issues or controversies. While discussions about democratic and bureaucratic ethos have been useful in understanding many public administration issues and in shaping the debates around those issues, they are less helpful in developing a fuller understanding of public values and in assisting administrators in understanding value conflicts as they apply changes to policy matters. The administrative branch is a policy-making center of government, and it must be structured to enable faction to counteract faction by providing political representation to a comprehensive variety of the organized political, economic, and social interests that are found in society. Consequently, this frame tends to view the individual as part of an aggregate group and identifies the individual's interests as being similar or identical to those of others to be considered within the same group or category. As this legal framework expands, it generally minimizes discretion in the name of explicitly guiding behavior. Law is intended to prevent the corruption, loss of rights, personalized authority, and other abuses. The principles of this approach are to be constitutionally competent, avoid illegal behavior in the exercise of authority, be broadly aware of relevant laws, and interpret law in a reasonable fashion. The view of law as a formal framework is widely accepted. The problems and controversies surrounding the role of law in public administration emerge when the law is viewed as a set of values that are to be used in guiding administrative discretion. This is not to suggest that the framers denied discretionary power to the national government. The Federalist 23 and many other papers of the Federalists could draw such a conclusion. They understood that such discretion had to be channeled through the forms and the law of the Constitution in order to be safe for liberty. Hamilton explained in Federalist 23 that the vigorous discretion that the national government must have is made safe by the most vigilant and careful attention of the people. For the people to exercise this kind of vigilance, the officers who exercise discretion must do so in a system of clear electoral accountability and within the confines of the rule of law. Substantive rights refer to the cluster of rights generally involved in interpretations of the Bill of Rights, which are the first 10 amendments to the Constitution and the 14th Amendment. For example, the Bill of Rights provides that the substantive rights of liberty, including freedom of speech, a free press, free assembly, free association, the right to hold private property, the right to counsel, and the rights against unreasonable searches and seizures and cruel and unusual punishments, grants the rights of all persons born or naturalized in the United States to be citizens of both the nation and the state in which they reside, and guarantees equal protection under the law. Procedural due process is the principle that the government must respect the legal rights that are owed to a person according to the law. Procedural due process cannot be confined to any single set of requirements or standards, but rather stands for the value of fundamental fairness and is viewed as requiring procedures designed to protect individuals from malicious, arbitrary, capricious, or unconstitutional harm at the hands of government. This should underpin the force and legitimacy of all government decisions. Equity in a legal frame is equal protection. Like due process, equity is subject to varying interpretation. However, in terms of public administration, equity stands for the value of fairness in the result of conflicts between private parties and the government. The elites, not the masses, govern the United States. The founding fathers were also rich, well-born, talented, and educated. They understood that due process provides protection against arbitrary or invidious treatment of individuals regardless of societal status, and encompasses much of the constitutional requirement of equal protection, enabling the courts to fashion relief for individuals whose rights might have been violated by administrative action. Procedural due process is enumerated twice in the Constitution. In the Fifth Amendment, it limits the powers of the federal government. In the 14th Amendment, it limits the powers of state governments. Both read that no person shall be deprived of life, liberty, or property without due process of law. To uphold these values, legal rationality is employed. To make the necessary determinations in legal reasoning, one looks to both statute as well as common law. With these steps, deductive and inductive reasoning are used, the general rule associated with the claim, and the sub-issues, and then specific exceptions to the rule in any cases that need to be distinguished, and then the more specific cases to the general standard. In terms of discretion, although law often sets the parameters from which administrative action takes place, legal compliance tends to be the paramount concern for public administrators, rather than discovering or promoting higher order legal or other values. The content values of the legal frame might be categorized as regime values, the values that are manifest in the Constitution and represent the values of the American people. Although it might be difficult to supply an exhaustive list, scholars have identified 3 values that are central in the legal frame of public administration: individual, substantive rights, procedural due process, and equity. The consequences of adopting progressive ideas as the foundation for a major piece of contemporary government are profound, especially when one considers the impact of these ideas on the bedrock principles of our Constitution. This paper, therefore, concludes that more concerted efforts should be geared towards theorizing old, contemporary ideas and the new terms in public administration, so to gain an in-depth understanding of the causes and consequences of policies and the discretion along with the rule of law, as well as building new fields of inquiries, and to continue clarifying and directing the inquiries into policy making, governance, ethics, among other subject matters within the purview of public administration.